Okay, so you also handle insurance coverage disputes, right? So when an insurance and their insurer and their holder disagree, how do you decide which side you're on?
Well, I'm almost always representing insurance companies. In fact, our firm policy where we're at now, we represent insurers. I can't take a position adverse to an insurer. Some of the most fun I've had as a lawyer is at former firms where we did do work where we sued insurance companies. That was fun. I can't do that anymore where I'm at. Not the whether even if it wasn't a direct conflict, suing a client of our firm. Our firm is big enough to where we represent nearly every insurance company in one way or another, or one of their subsidiaries. So we would run into some sort of conflict. It's been a long time since I've done that work. So I always represent insurance companies. That's been the bulk of what I've done over my career. Well over 90% of what I've done is represent insurance companies or their insureds. I've done very little plaintiff's work, many, many moons ago in galaxy far, far away. So no, I always know I'm going to be representing the insurance company, and sometimes you tell them, yep, that's a good position, we can do that. And sometimes you tell them, maybe we should find another way to resolve this particular dispute because your position is not very good. And our job is to try to see around the corners and tell them, this is one to fight on, this is one not to fight on, or we can fight on it, but understand we're just doing this for leverage. We're not doing this because we think we can actually win. And they have to figure out what they're going to do. Our job is to provide advice. Their job is to decide how they want to take that advice, and because ultimately it's their money. We just provide advice.
You filed amicus briefs on behalf of entire defense organizations. What makes a case important enough to rally the whole defense bar behind it?
Wow. It depends upon the case. I know you'll love that answer when a lawyer says it depends. But I'll give you the most recent amicus brief that I filed. The two most recent amicus briefs I've filed have been in cases jointly with the plaintiff's bar. And those two cases, the most recent one is a case called Hensley versus Nornat before the Illinois Supreme Court that has not yet been decided. And the other one was Scarbeck versus Woodman's Market. And that was a case before the Illinois Appellate Court, Second District. And that second case, that opinion has been issued, and we supported the plaintiff, which was the winning side in that case. That dealt with an electronic filing rule. And in that case, what made the case so important was clerks in Illinois are empowered to reject submissions. And all lawyers, whether they're plaintiffs or defendants, have time-sensitive, case-dispositive filings. That is, on the defense side, notices of appeal, motions to reconsider, counterclaims for contribution, things that if post-trial motions, things that if they're not done, the court loses jurisdiction or can't decide your case. An appeal from an administrative review, all things that have to be done by a particular time. And the clerks have been rejecting things, and we weren't very happy about that because this could happen to any of us. Now, most of the cases where this has happened have happened to plaintiffs who didn't timely or had their complaint rejected, the submission of their complaint rejected, usually for reasons that were frankly ridiculous. In the Scarbuck case, it was the lawyer did not attach what's called a Rule 222 affidavit. The Rule 222, in the kind of case he was filing, didn't require such an affidavit. And for the clerk to have rejected it for not having filed it made the clerk superior to the judge. And as we told the appellate court, two things we told them, among many other things. We told them two things. Number one, all the defects in pleadings are to be decided by motion. That's what's in the rules, number one. And number two, if a judge found a complaint wanting, unless that judge really wanted to get reversed, if it was the first time the lawyer had made this error, or it was the 10th time the court made the error, the lawyer made the error, unless he really wanted to get reversed, he better give him time to fix the error. Why would a clerk who has a critical but nonetheless ministerial task have greater leave to prevent someone from filing something? And so we said, no, this is ridiculous. You can't have a situation where clerks are empowered this way. And this is not a reason to reject it. The case should be decided on the merits. And so that we filed that brief. And then the brief we filed, and the court agreed with us, fortunately.
So
The
I have a
case,
question
sure.
about the philosophy behind that, because I can hear the angst of how ridiculous this is. How often do you, but I want you to expand on the rest of this, but it just occurred to me, how often do you have something that is ridiculous on prima facie? You just see this is just like, so anyone obvious or reasonable person, this is a ridiculous thing, but it doesn't get taken care of.
Often, often. It let me explain. This is all public. When there was a case that came down in the fall of 2023 that kind of got everybody's, and by everybody I mean everybody in the litigating bar in Illinois, very worried that they could reject a complaint for this kind of an error. And in that case, it was because the lawyer put his Cook County number. He was filing in Lake County, Indiana, so it's the county immediately north of Cook County. Cook County is the county that contains Chicago.
Mm-hmm.
He was filing in Lake County, the seat of which is Waukegan, and he didn't put his bar number. He put his Cook County number on the pleading, and for that grievous error, his complaint was rejected. And when he went to resubmit it, the time to file it had run. And the appellate court said, yeah, you can reject it for that. And now the plaintiff loses. Well, the plaintiff lost their tort case and got a legal malpractice case, is what happened. That's no doubt what happened in these cases over a number that no one was. And let me just put a very fine point on it. And I have to get my pen for this. In the days before electronic filing, if that error was made and if the clerk caught it, the clerk would have said, you have the wrong number there, Mr. Attorney or Mrs. Attorney. And the lawyer would have taken out their pen. They would have scratched out the number. They would have written the correct number, and they would have filed the document. Or in the days in Cook County where we had for no fee filings, so this wouldn't apply to a complaint, for no fee filings, you could file a roll of toilet paper because they had a stamper. You go over, you stamp it, you put it in the bin. You can file anything you want in there. So the idea that because we've adopted electronic filing, we now are going to start rejecting things over things that you could correct with a pen. That's not a thing. Mm-hmm. And it shouldn't make, and so then you'd have lawyers say, well, you filed or you submitted the thing on the last day. And so we pointed out, well, sometimes you get the information on the last day. Sometimes you get the case on the last day. Sometimes the client takes forever to approve what you want to file. But guess what? The legislature that wrote the statute of limitations said there was a last day. Not a week before, not a month before. They said you got to file by that, 2 years after whatever the date is. They didn't say, oh, if we have electronic filing, you have to submit early. That didn't happen. And so the mere fact that we adopted a new system for filing that's supposed to make things more expeditious, that truncates the statute of limitations. Well, that doesn't seem very just. The statute of limitations serves a critical role, a very important role, but it is a fixed time. It's midnight by that date. That's the time. And it's not shorter than that. It's not longer than that. And the way that the clerk accepts or doesn't accept or processes submissions shouldn't make it longer or shorter.
So I want to talk to you about reptile theory because I had this conversation probably a couple months ago. You co-authored a major piece on reptile theory for people who've never heard of it. What is it and why should they care?
What is reptile theory? How long do you have?
I had the similar conversation before, but
this reptile theory is a theory that has been developed by the plaintiff's bar, and it's very clever. And it not essentially, I hate using the words essentially and basically. I do it, I shouldn't. What it does is it tries to tap into the baser aspects of our nature and appeals to things that should be kept out. It is a way to repackage golden rule and community protection arguments that are beguiling in how attractive they are.
Mm-hmm.
They are the siren song of logic. Only they're not. They're wrong. They're incorrect almost always. And there are things like, well, wouldn't you agree, Mr. Defendant, that safety is the number one priority? And the answer to that question is, of course, it's number one, you can't have more than one priority. And number two, if it were, we would all drive tanks. We don't drive tanks because we've made the decision as humans that we're willing to sacrifice a lot of people on the roads of the United States every year in exchange for we actually want to get someplace. And if we had to buy tanks, most of us wouldn't be able to drive. There'd be like 3 tanks on the road, and the rest of us would walk or take a scooter. And all of those things would be less efficient, and we don't do those things because it turns out safety isn't our only concern. Look at what anybody does. If safety were our only concern, we would stay in our basements. We wouldn't go anywhere. We wouldn't do anything. We would literally do nothing. So it places this idea of to be attractive to people about how big bad the corporation is, and it ties in with this idea of profits over people, which is a theme that you hear, and it's that the jury's job is to protect the community. No, the job of the jury is not to protect the community. The job of the jury is to decide the justice between these two parties in this particular case, based upon these facts. And that's it. And my undergraduate education was at the University of Chicago, and I learned in my philosophy class I took the difference between fairness and justice. And what's the difference between fairness and justice? And this professor says, I was walking to class. It was the late 60s. There was a riot. The police had come, and they were whacking everybody on the head. Now, I was walking to class. I wasn't rioting. I got whacked on the head. Was it just that I got whacked on the head? No, I wasn't rioting. Was it fair? Yeah, everybody was getting whacked on the head. So that's the difference between justice is about what you deserve. He didn't deserve to get whacked on the head. He got whacked on the head anyway because it was fair. Everyone got whacked. That's how it works. And that's understanding the difference between justice and fairness. And the purpose of the civil justice system, it's in the name, justice, is to give people what they deserve. That's all it is.
So I want to talk to you about power, specifically about nuclear power, because I know you've been involved in some of that. So there's so much of a discussion now with AI about consuming all these massive amounts of power. And we've been at a standstill with nuclear power for what, like 50 years, I think. And it from everything that I've been able to discern about nuclear power, it is the most efficient type of power. And really, in essence, all we're doing is heating water. In essence, people think something else about. So talk about nuclear verdicts of $10 million or more are becoming more common. Is that system broken, or is this a correction?
So what you're talking about there is combination of social inflation, this idea of nuclear verdicts and these thermonuclear verdicts. And just so people understand the terms we're talking about, when a person says a nuclear verdict, they're referring to a verdict of over $10 million.
So we're not talking about nuclear power. We're talking about nuclear verdicts. So what do you call it? I'm putting the wrong things completely together there. I've totally screwed up our audience. I'm sorry, audience.
I think we're talking about nuclear verdicts.
Thanks for straightening me out on here. I seem like a neophyte.
You're doing fine. And so thermonuclear verdicts are verdicts where there's a verdict of over $100 million. And yes, those have increased everywhere, not just in cities. Across the street from where I'm sitting is the Daly Center, which is where most of the large cases in Cook County are tried, if not all of them. But they all across the country in smaller venues where you never would expect it. And there's a whole range of reasons why that has happened. Certainly, there is some effect. We can argue about what the cause of that effect is since March of 2020 and the way in which different people reacted to COVID and to the pandemic. Certainly, there's an echo chamber, though, and this relates to the multi-billion-dollar industry that you're referring to that I'm involved in combating to an extent, is there's an echo chamber with on television and billboards of here's what cases are worth, and it has an effect as people get desensitized to how much these cases are worth, and then those advertisements also include things that they get to say to prospective jurors that they never will get to say in the courtroom, such as there's really an insurance company there. That's really the insurance company that's paying. It's not that poor lonely individual, because one of the things that defense counsel tries to do is humanize the defendant. The defendant is a small business. Even if it's a big business, it's a business that does these things for the community that without which people would be worse off. It does things it's real people that are impacted by this. It's not just some nameless, faithless corporation. And that's part of the resistance to it. But it is certainly a concern to the insurance industry, the size that verdicts have become. There's risk all over the place with that. And we as defense lawyers have to develop tactics, and we at our firm have a whole range of programs to try to deal with that and avoid those situations. Not that we don't get hit with verdicts like that. It certainly happens. If you haven't been hit with a big verdict, you haven't tried enough cases. That's an expression, but it's true. But it's certainly something that's happening across the country for a whole variety of reasons.
So here's my question about that. Since we're not talking about nuclear power, now I'm gonna go down on that one. But on these nuclear verdicts, I do hear about them all the time, about these really huge verdicts. But then frequently we don't hear that later that those were appealed and they end up at a much smaller. So what percentage of those huge verdicts actually end up standing up on appeal?
It's hard to say, because many times you just don't know, because the appeal is used sometimes as a lever to settle. There may be other ways in which the case gets resolved. Many times you get a giant verdict and in fact it's uncollectible. I could give several examples of that where they just tried the case in order to get a verdict, so they could say they got the verdict, never anticipated that they're actually going to be able to collect that money. Mm-hmm. Very seldom. Certainly there are occasions where you're able to collect. It will take the example of the first of the Sterigenics verdicts, where they got $300 and some million. Now, $300 million of that was punitive damages. Now, it was against a large company that may be able to pay a $300 million verdict, but none of that would be covered in Illinois. You can't cover punitive damages. So it wasn't coming from the insurance company. The $30 million underlying judgment compensatory award was, but not the punitive damage award. So it's hard. We just don't know how much of it is collected. I can tell you in some of the cases I've been in, I was involved in a case that we got hit for more than the policy limit. And it was negotiated. There was a resolution short of the verdict, and in order to avoid the appeal. And so that's oftentimes what happens if there's issues. Many times there are arguments to be made, but sometimes the verdicts just get paid. That's what happens. There was a verdict down. I'll give you an example in Kendall County, county to the southwest of Chicago, where there was a young man who was thrown out of a bar. And the first time they tried the case, they got 40 some million, and it got reversed on appeal. And the second time, just got argued here a couple weeks ago. The second time they got 48 million, I want to say, 20% off or 25% off a $65 million verdict. And from the sounds of the oral argument, that might get reversed again. I'll give you another example where a case is it's going to go back for its third time to be tried, in a case where the plaintiff got $43 million twice. Verdict number one, $43 million reversed because of misconduct by defense counsel of a Reptile variety during the closing argument, and then shenanigans with trying to taint the jury with postings on his website during the second trial, and that verdict got overturned on appeal, and now they're going back to trial number 3. So it does happen, but defendants shouldn't count on winning in that way. Cases should be resolved when they can be, and cases should be tried when they can be. And sometimes if you try cases, you lose. that's part of the risk of trying cases. Sometimes things don't turn out the way you want them to.
So you both predict case outcomes and track your records publicly. What's it like being wrong on the record?
I will say this. That segment of our show is called Predictions Sure to Go Wrong, and that is not tongue in cheek. When we started, Dan and I were convinced we are going to be so far in the hole, we're going to make my Chicago White Sox look like a good team. I can't believe that we're 460 some and 100 and some, something like that. I forget where we're at. We're very judicious with the punts. We've had 50 punts where we're going, we don't know. We just don't know. But Dan, I think, is up a couple on me. I think he's 462 and a half, and I'm got 460, and we've both got around 100 and some ones wrong. I can't believe we've done as well as we've done. It's remarkable.
So
it's dumb luck.
You've led the PLDF as president, and you're rising through Illinois Defense Council.
I am. Right.
What's the biggest challenge facing defense lawyers right now?
Defense lawyers generally, it's getting paid. it's
really.
It's
because I would think that the defense lawyers, frequently have, they have clients with big pockets.
We do, but when you do work with insurance companies, there's no more sophisticated consumers of legal services than insurance companies, and they know how to write down our bills, and they put restrictions on us, and they do a lot of things. So it's making sure we get compensated for our work. In fact, I was just sending an appeal before we got on about a bill that got written down for work we did that they thought a paralegal should have done, and I went, no, that was definitely a lawyer work. It was drafting a motion. A lawyer needed to do that. That was not anything that a paralegal could do. So we have real challenges regarding technology, integrating it, using it, affording it, recruiting, training, and retaining young talent. It's an extremely expensive undertaking. We have done a very good job in our Chicago office, knock on wood, of recruiting, training, and retaining our young lawyers. Hopefully we keep that up. And that's a huge challenge. The challenges are many, but the core of what we're trying to do in developing our young lawyers is one of the most difficult challenges that we have. But but we have to start by getting paid, and the billable hour is that's how insurance companies are very familiar with that. They know how to do it. We know how to do it, and trying to bill it in such a way that they actually pay it.
So this is quite a bit different than being a basketball coach.
You'd be surprised. The skills I used and the things that come into play in coaching basketball and being an office chair of a large firm, of a law firm, are not that different. On more than one occasion, when it comes to recruiting lawyers to come join our firm, I have said the bad ones you take will hurt you more than the good ones you don't get. And the reverse of that is true. So you got to get good lawyers if you want to your team to do well. There's not much it's in that regard. Yeah, we're not trying to put orange balls in round hoops, but we're trying to do many of the same things. We have to work as a team. We've got people who bring in business. They would be the scorers. We've got people that got to go do the rebounding and the shot blocking and the defending and the setting of the screens, and we've got those people too. And we've got people that we're trying to develop. So you've got it's not really that different. There's people, and you've got a goal you're trying to get. And if you can get everybody pulling the same direction, we don't have a scoreboard, we don't have a record, but doesn't mean not everybody's keeping score. They each keep score a little differently. Different things are important to different people, but it's not different. Turns out there's humans in both endeavors.
So if you could change one thing about how the civil justice system works today, what would you change?
In Illinois?
Sure, yeah.
One thing in Illinois, my goodness. Uh, I get to wave the wand and change one thing.
Yes. Just one, though.
I understood that. It's wow. That is quite the question. There's so many things. Um, we have fought for a long time in Illinois to overturn legislatively a case called Reddy versus Godecki, or Reddy versus United, which was an amendment. This is getting really arcane, uh, which forbade settling defendants from being on a verdict form, and you can't apportion fault to the parties that are settling. And we have long argued that that is improper, that you should put everybody who's potentially liable on the verdict form. Employers, settling defendants, everybody goes on the verdict form, and the jury can apportion fault between them.
Mm-hmm.
And if you made that change, that would be a substantial change. We have long lobbied for that change. I will be old and gray before it ever happens. But that's why I mention it, because we fought. That case came down in 2008, and we've been fighting that fight for a long time. That's very arcane, but that'd be the thing we'd start, because that's the thing we keep banging our heads on.
So you testified before the Illinois Senate. I sound an out of town guy. Illinois Senate Judiciary Committee. What was that like?
So I've done that most recently. It's been a while since I did it most recently. That was on special interrogatories, and we testified, went down to Springfield twice on that. First in front of the House and then in front of the Senate, and that dealt with how we deal with special interrogatories. Illinois has general verdicts, and so they don't ask specific questions about particular legal or factual issues. It's a general verdict. And this allowed juries to be asked questions that tested that verdict. And there have been some verdicts that had gone the way the plaintiff's bar didn't like very much. And so we went down and argued that the system we had was good and should be kept. And that argument did not go the way we would have liked. Or that decision, I should say, did not go the way we would have liked. And the rules have changed. But special interrogatories, you continue to see their importance. It was a wonderful process to be a part of, even though it didn't turn out the way I would have liked. And very few of the legislative efforts I've been involved in over the years have ended up the way I would have liked. Our job, we see it as to make things less bad. I think we did that with prejudgment interest when that was an issue here. We did that with a number of other issues over the years, trying to bring attention to the legislators. Hey, this is not the best idea. Let's try to moderate it here or there. And that's kind of our role, because that's all we really have the ability to do. That's not telling any secrets. That's just the reality.
So if there's an insurance company listening or some sort of professional that needs your assistance, what's the best way to get in touch with you? They say that Pat, he's sharp. I want to talk to him.
Well, you would either email me at patrick.eckler@fmglaw.com or call me at 773-389-6446. I work strange hours, so you can reach me early in the morning. That's for sure. But email and phone are probably the best. I'm also on LinkedIn at Donald Patrick Eckler, and on our website at fmglaw.com.
Okay, Pat, thanks for coming on. Hang with me for just a second here. Welcome to another edition of the Trustcast Show, and we have with us today Pat Eckler. Thanks for coming on the show, Pat.
Thanks for having me.
So Pat was a history teacher and a basketball coach before he ever set foot in law school. And today he co-chairs the Chicago office of an AmLaw 200 firm. In other words, they're one of the largest firms in the country with over 500 attorneys. He writes a legal column, co-hosts a podcast with 305 plus episodes predicting court outcomes, and sits on a national task force fighting a multi-billion-dollar industry most people have never heard of, and we'll get into all of that. So you went from coaching basketball and teaching history to co-chairing a major law firm's Chicago office. What made you walk away from the court and into the courtroom?
Life. It turns out that basketball coaching, which is what I wanted to do, and what I spent a lot of my parents' money doing in as an undergraduate uh, isn't very stable, and it went to law school. And while I was in law school, where I was a terrible law student, I had a scouting service. I drove all over the state of Florida, watching high school and junior college basketball players, and recommending them to be recruited by schools around the country. And then my plan was to go back and coach college basketball. And then life happened, and woman who I was going to law school with got a job at a big firm here in Chicago and said, "Why don't you come back to Chicago where I had done my undergrad?" And I said, "Sure." And I came back, and because I couldn't get a job coaching basketball, I said, "Well, I have this law degree, and why don't I go practice law?" And so I did. And because of a very bad Supreme Court rule, because I had taken the Florida bar first, I could not be what's in Illinois known as a 711 for the public defender's office, which is what I had trained to do. I had done every criminal law class they had done. I had done a criminal law clinic at the public defender's office in Alachua County, and got an interview with the public defender's office in Cook County, and they interview's going great. And at the end, he says, "What's your bar status?" And I told him I had taken the Florida bar the month before and was taking the Illinois bar in a couple months hence. And they said, "We can't help you." And it turned out they couldn't, because I had not taken the Illinois bar at the first opportunity. And so I was unable to work for peanuts representing the indigent, and I had to go find a job. And that job turned out to be working at Borders on Michigan Avenue while I studied for the Illinois bar, and got a job with a fellow Gator. And that has turned out to be the work I did there is the work I still do. And one of the people who I worked with there now works with me at my firm currently, and I represent many of the same clients that I represented 20 some years ago, just in a different platform.
Wow. So explain that. Representing the same clients that you did 20 some years ago.
So the firm I got a job with was doing primarily insurance coverage and doing insurance defense work. And a lot of those same clients that write what's called non-standard personal lines auto are a lot of my same clients now. And that's the work that I have done. I do a lot more complicated things now. In addition to that, professional liability and higher levels of coverage and commercial litigation and other things. But a lot of what I do is personal lines auto, and very unsexy, but they are not well liked by many in the judiciary, and they need good lawyers, and so they hire me to go be their good lawyer.
So personal lines auto, is that what I traditionally just think of as your personal auto insurance?
Exactly, and a certain class of that market that handles things in a particular way that isn't very popular.
So you're what we'd what we'd call the insurance company.
I represent insurers. Yeah, absolutely. That is what I do.
So you moved through several firms before landing at Freeman Mathis and Gary. What made them the right fit for you?
So I had been at a firm for many years. It was a wonderful place to be, and it was one office. And from a business perspective, I wanted to grow my practice, and so I wanted to find a national platform from which to do that. And I was recruited to go to another firm, and then I had this opportunity thereafter, and to open the Chicago office with one of my partners, Jonathan Schwartz, and the two of us, two associates, two assistants, and a paralegal opened the Chicago office just over 4 years ago. And now we will shortly be close to 30 lawyers. And we've just finished out an expansion here of the entire floor, and may have to expand more as we continue to add more lawyers. So we've added two associates so far this year. We've got two partners coming on board, or three partners now coming on board, and four associates starting with us, first year starting in September. So we've got a lot of expansion. We've had a great growth here in Chicago.
So what do you attribute that growth to? Do you do a lot of marketing? What do you attribute that to?
So my partners, Jonathan Schwartz and King Roy, we primarily are responsible for the business in this office, along with some others, and we have, in our own different ways, have marketed quite a lot and been able to build our business. Last year, we had a phenomenal year growing the office in terms of the business. Now we're filling it in with people to do the work that we've brought in. Yes, there's a lot of marketing, but it's a lot, mostly, especially in King and Jonathan's case, good work. And as I say, each one of us market in a slightly different way. But I still think that Charlie Munger's line that 80% of your new business is already on your desk holds very true. And that has been where most of our work has come from, by doing good work, servicing the clients we have, is where most of the work has come. The client that my biggest client, my first client, that opened 17 years ago, is still one of my largest clients, and they've been my client the entire time they've existed. And they've gone from a startup to writing over $100 million in premium, and so they've become the largest carrier in their segment of the market. And I'm a small part of helping them do that, help them build their business and grow. And that's you do good work, they grow, and you get more business.
That's awesome. So you defend lawyers, accountants, insurance brokers when they get sued. Walk me through what a typical professional liability case looks like from your side.
I don't know if there is a typical legal malpractice or other professional malpractice case, because usually you're involved with a professional who, and oftentimes more than one professional, that got together and thought they had a great idea. And that idea sometimes turns out not to be so good, and they get sued for it. It's usually more than one lawyer that says, yeah, we should do this, and then hilarity ensues, or not so hilarity. It is always challenging to represent professionals because the work that they're doing is, sometimes you don't know anything about their area of practice. You have to learn their area of practice. You have to begin to understand why they did what they did. And our job is to try to understand and show why what they did either was within the standard of care, or it didn't, or whatever they did, if it wasn't within the standard of care, it didn't cause any damage. There's a variety of ways in which you defend these cases. There is no cookie cutter in professional liability. It is there's all kinds of different ways for people to screw up, or people to claim that the lawyer screwed up, and all kinds of different ways for people to be damaged, or claim that they were damaged. And our job is to either show that there was no breach, there was no causation, there was no damage, or some combination of all three. And that comes in a variety of different ways, depending upon the professional and the client and whatever else.
So what's the most common mistake you see professionals make that leads to malpractice claim?
Lack of communication. Every study, every report from a bar regulator, everyone is failure to communicate, or failure to communicate clearly what you were doing. And so it is a great reminder as a practicing lawyer to not do what some of your clients have done or not done. That is, communicate. And it's the hardest thing to get one of the hardest things to get young lawyers to understand is, we have to tell our clients what we're doing, why we're doing it, what we're going to do next. And guess what, young lawyers? You could bill for all that. In fact, that's what they're paying you for, is for your insights about, here's what happened, here's what it means, and here's what we're going to do about it. And maybe what happened was good, and maybe what happened was bad, but this is what our plan is. And it forces you to think about what happened and what you're going to do about it. And it forces you to then report, and you get to tell the client, and they'll pay you to tell them, because that's what they need, especially insurance companies. They live for that information, because that's how they figure out how they reserve, and trying to explain to young people what a reserve is and how it works and how it impacts their business is really critical. Because if they don't understand our client's business, and insurance is a very unique business, then they're going to have a hard time servicing them. So we have to spend time explaining to them how the insurance business works, and I don't want to bore your listeners with that, but they live for the reporting because that's how they survive. That's how they determine risks. That's how they reserve. That tells them how much premium they're going to be able to write and everything else about their business. And it all comes from the reporting that they get from the lawyers, which is why their reporting requirements are so stringent.
So hang on just a second. I'm going to restart this because I want to turn on your echo cancellation in case I have any challenge. So just one second. But I usually don't, but just